Baroness Fox of Buckley.
My Lords, I want to start by making a general comment that's been concerning me about all of the amendments on cross-examination on special measures. I also want to start by apologising that I'm not a lawyer and apologising that I think I might not have quite grasped what the committee stage is, because I think I could have been jumping up in all of these amendments and I've kind of bundled them into one. I hope that's going to work. But anyway, I won't do it again if I've got it wrong, if you see what I mean. Can I quote the noble Lord Paddock, who I just want to note actually in general I found hugely helpful and insightful throughout these committee discussions on this bill. But something he said on the committee stage on Monday did trouble me. He said, "My Lords, for reasons of brevity and clarity, I will refer to the person to whom a domestic protection notice is given as the perpetrator rather than the alleged perpetrator or defendant, and the person the notice seeks to protect as the victim rather than the complainant or alleged victim or plaintiff." And Lord Paddock concluded that clearly it will be up to the court to decide ultimately whether they are in fact perpetrator and victim. Now, I understand entirely the noble Lord Paddock's shorthand point, but I get anxious that sometimes that sort of shorthand becomes the presumed fact or reality, and has done throughout these committee discussions, and nowhere more obviously than in this discussion about cross-examination. And I worry that that might prejudice justice and fairness in proceedings. As the noble Lord Paddock rightly stated, it is up to the court to ultimately decide on guilt and innocence. And in the context of the court making such weighty decisions about guilt and innocence, it seems to me that cross-examination is a key part of that. To test the evidence thoroughly is a very important, and demands for special measures for cross-examination shouldn't compromise that important aspect of testing the evidence. Already we have heard in some ways the way this can happen. We already heard from the noble Lord Marks of Henley-on-Thames in calling for special measures. He said that in an earlier set of amendments, if a witness claims that they are frightened, that this can be seen as sufficient to treat the alleged perpetrator as having to be seen as a perpetrator and the alleged victim as securing special measures. And I just get worried about a kind of slippery slope. So for me, because of the importance I place on cross-examination, actually, I'd like to say that in relation to the distinction between family courts and civil courts, I'd actually prefer in both courts that a legal representative was appointed by the courts in order to facilitate the most objective, thorough cross-examination and to make sure that the evidence is objectively tested. But on this specific set of amendments then, on special measures and why we need special measures in civil courts, I just don't feel as though this requires legislation at all. I think that to have interchangeability between civil courts and family courts actually is going to confuse things, and the arguments that have been put, that we've heard for it so far, puts an emphasis on the witness's vulnerability as a reason to make this demand for special measures in civil courts to bring that into the law. I worry about that emphasis on vulnerability because I worry that this might become an overly deterministic label. Civil cases may be intimate, and then, as indeed the bill already states, the judge has the discretion to act in relation to special measures. But civil cases may be, and we've already heard, a multitude of different issues, and they may happen many years later and not be directly concerning either abuse or alleged domestic abuse. So I think that there is a danger here that we will always see the witness as a vulnerable victim, even if they're arguing over something relatively trivial like property, not always trivial for people, but a whole different set of issues. Domestic abuse can be traumatising, but it is also something which can be and often is overcome. Are people forever to be victims and assumed traumatised in all context in perpetuity, in every single instance of a civil case in the courts? Surely that would be disempowering, and ironically it can re-victimise people, actually often women, by forever seeing them as the victim in need of protection and special measures. But conversely, even if a perpetrator was convicted, are they always to be seen as an abuser in all context and in perpetuity in every instance that you might find yourself in a civil court? And we've already heard how important it is not to dismiss spent convictions under the headings of patterns of behaviour or repeat offenders. We must ensure, therefore, that we hold our nerve in not compromising on our commitment to drawing a line and the humane aims of rehabilitation. And on that, actually, to go back to where I started, I support the Noble Lord Paddock on that issue. So for me, I will be rejecting these amendments. I think that the civil courts are distinct and different, and I think that by emphasising people who may well have been victims as perpetually victims in all instances does those victims no favours whatsoever.
I now call the Minister, Lord Wolston of Tredegar.
My Lord, as the Noble Lord Marks of Henley-on-Thames has explained, these amendments intend to bring the provisions relating to prohibition on cross-examination in civil courts into line with the provisions on the same measure in family courts. And as the Noble Lord himself explained, we have covered some of the questions of principle already in earlier groups. He indicated that he was going to be brief, therefore, to the committee, as he indeed was, and I hope both he and the committee will not take it as any disrespect if I am equally brief in response, given that we have canvassed the points of principle already. I do, however, wish to pick up, if I may, the noble Baroness Lady Bennet of Manor Castle when she described herself as a support act, an appellation with which I respectfully but firmly disagree. She spoke eloquently in an earlier group of her personal experience of seeing how court procedures operate in cases involving domestic abuse, and her contribution to this short debate has been equally as valuable. While picking up in that context members of the committee, I hope the noble Baroness Lady Fox of Buckley will forgive me if I gently point out to her that she shouldn't apologise for not being a lawyer. What is apparently, in my short-term time here, a repeated cause for apology in this House is generally regarded as a badge of honour everywhere else. With those introductory remarks, let me turn to the substance and explain that the approach we've taken in respect of civil cases, which does differ from the approach we've taken in family proceedings, and for good reasons. The clause in relation to banning cross-examination of vulnerable parties or witnesses stems from the report by the Civil Justice Council, which I spoke about in relation to my comments when I was speaking to the amendments of Clause 62, and to which the Noble Lord Marks also referred. The Council recommended that the prohibition of cross-examination by a self-represented party should be extended to cover civil proceedings, and thereby ensuring some parity with the criminal and family jurisdictions. But importantly, the Civil Justice Council did caution that the ban or prohibition should not be absolute. Rather, it should be left to the court's discretion, given, as I explained in an earlier group, that the civil and family jurisdictions are very different as regard the types of cases, with the civil jurisdiction having a much wider range. As I said in an earlier group, those cases can have a much broader range of circumstances where there is no prior close connection between the parties, as there would generally be in the family courts. And therefore we have tailored our approach to allow for those differences, and that is why the provisions in respect of cross-examination in the civil jurisdiction differ to those in family proceedings. And I hope, my Lords, that explains my thinking to the noble Lord, Lord Marks. Importantly, and in response to points made both by the noble Baroness Lady Bennet of Manor Castle and the noble Baroness Lady Fox of Buckley, it is important that two things are fundamental. First of all, that protection is available to all witnesses who need it, which was the point made by Lady Bennet. And in response to Lady Fox's point, of course, in that regard, the court will look at all circumstances. The overriding concern is to ensure that justice is done in the particular case. And that is why leaving it to the discretion of the judge in the individual case to decide when a ban is necessary, based on a range of factors, in fact an unlimited range of factors, which would include obviously the views of parties to the proceedings, any past convictions or behaviour of parties during the trial. That is the way we suggest that this matter is best resolved. Having said all of that, the noble Lord Marks has, if I may say respectfully, put forward, as one would expect from him, a cogent and well-argued case for his amendment. So while we consider that the approach taken in the bill in relation to the civil courts is well-founded and certainly not illogical, to use a word which was adopted earlier in this debate, I do hear the arguments put forward by the noble Lord, and I undertake to consider these amendments further ahead of report, and I will continue to listen with interest to any arguments made by him or others in this regard. And I hope, therefore, my lords, given that undertaking, the noble Lord will be content to withdraw his amendment.
My lords, I have received no requests to speak after the minister, so I now call Lord Marks.
My lords, once again, I'm grateful to all noble lords who've spoken in this debate. I certainly agree with the noble Lord Wolfson that the noble Lady Baroness Bennet of Manor Castle has proved herself much more than a support act. And I say to her and to Baroness Fox of Buckley that there is a crying need in these legal debates for experience from outside the law to inform our debates and bring the lawyers down to earth. My lords, many noble lords may well have formed the view that the differences between the noble Lord Wolfson and me are arcane legal arguments in some senses, but we can only have those arcane legal arguments in a relevant way if we have real world experiences to back them up. Some will be ours, but the noble Lady Baroness Bennet of Manor Castle clearly demonstrated not only how the same principles apply to cross-examination in civil proceedings as apply in family proceedings, but she graphically described the personal experience of witnesses in court proceedings. And I challenge anyone to explain why that experience differs between the two types of proceedings, where witnesses are victims of or liable to be victims of domestic abuse and where they are vulnerable. My lords, although I greatly valued the contribution of the noble Lady Baroness Fox of Buckley, I don't agree with the noble lady that this legislation and these amendments and other amendments overstate the significance of vulnerability or trauma when the evidence is serious and extensive of how deep vulnerability can go, of how serious the trauma can be, and of how long-lasting it can be as a result of domestic abuse. And that is the reason why the government have brought this bill. That is the reason why it is widely welcomed around the House. And that is the reason for the protections that are afforded to witnesses and parties in court proceedings. My lords, coming to the noble Lord Wolfson, he frankly accepts the differences between us and the parallels in respect of cross-examination to those in respect to cases of special measures. I don't accept that a discretionary system in relation to the prohibition of cross-examination is an acceptable substitute. And one of the principal reasons for that is that a party or a witness has no assurance that there will be a prohibition in a discretionary case. She is totally reliant, or in some cases he is totally reliant, on judicial discretion, having regard, as the noble lord says, to all sorts of other factors, including previous convictions and all the circumstances of the case, in knowing whether a prohibition of cross-examination will be extended. That means that such a witness or party is exposed to the risk that there will be direct cross-examination, which they may well be unable to face. My lords, I'm very grateful to the noble lord for his undertaking that he will consider these amendments further. I know that undertaking is given with every intention that he will do so. I and others remain completely open to discussing these amendments with him, to refining them if necessary. But we do take the basic belief that vulnerable witnesses need protection from direct cross-examination on exactly the same basis in civil cases as is to be extended in family cases. And saying that, I wish to beg leave to withdraw these amendments.